Hello and welcome. Thank you for joining us here today. This is the first webinar in the K&L Gates series on emerging national security considerations for AMCs and research universities. Our topic for discussion today is navigating national security requirements in federal contracts and grants. I'm joined here today by my colleagues, Dave Yang and Sarah Burgart. You'll notice that we're missing Amy Hong. She has the best of excuses. She welcomed a baby girl into the world last night. So we are going to do our best to fill in her very big shoes. And you'll hear me and Dave talk more than we initially intended, so please bear with us. Dave is a partner in our Seattle office. He specializes in all aspects of federal procurement and grant compliance and obligations. He also is an experienced litigator in federal claims. I am an associate in our DC office. I practice both government contracts and international trade. I am the co-founder of our firm's U.S. National Security Law and Policy Group. My practice consists of advising on national security topics applicable to contractors and grant recipients, including Section 889, which we will talk about later today, as well as export controls and sanctions. And finally, joining us is Sarah Burgart. She is also an associate in our DC office. She is part of our government contracts, international trade, and our U.S. National Security Law and Policy groups. Sarah is a recent addition to the firm and has quickly become our go-to on the new cybersecurity topics that we are going to discuss a bit later. So here is our agenda for today. We are going to start with the differences between contracts and grants. We will then move on to Section 889, which is a prohibition on Chinese telecommunication equipment. We will then address cybersecurity requirements and considerations, and then finally, we'll take some time at the end to answer your questions. So first, we have a polling question, and we're interested in hearing from you. We want to know what types of federal funding does your organization receive? And so if you could take a minute and respond to our polling question, this will help us focus our presentation on what you need to hear and want to hear, and we'll let you know what the responses are in a minute. So I'll give you a second to do that. And just for those dialing in, again, the question is, what types of federal funding does your organization receive? The options are contracts, grants, a mix, or is there a difference? Okay, Katie, can you let us know the results? Okay, perfect. So a lot of you said that you have a mix, that you are receiving both contracts and grants, which is great because that's what we're going to talk about today. A couple of you weren't sure if there was a difference, but looks like the majority also said, about 9% of you said grants and 6% said contracts. So we will talk about all of these. So let's turn to our first topic, which is what is the difference between contracts and grants? Okay, so we're beyond commercial here. The government has a variety of interests that it wants to protect and also objectives that it wants to achieve. So examples include affirmative action requirements, increasing opportunities for veterans, eradicating corruption, understanding executive compensation, prohibiting texting while driving. The list literally goes on. So a very easy way for the government to implement these policies is to tie them to the receipt of federal funds. So basically, in exchange for these federal funds, recipient, you will agree to meet whatever terms the government, put in your contracting vehicle. And so To further ensure that these policies are implemented in a manner that the government deems appropriate, which can include widespread implementation, sometimes it will require even the indirect receipt of federal dollars to be bound by some of the government's terms and conditions. And as it turns out, not all federal dollars are equal. So here we were talking about two types of funding: procurement contracts and grants. So what's the difference? Government contracts are used by the government to procure goods and services. And those goods and services are going to be for the direct benefit or use by the federal government. So for example, if HHS needs pens for its staff, then HHS will issue a government contract to purchase pens. Government grants, on the other hand, are the provision of funds to carry out a federal purpose. So if HHS wants to promote AIDS awareness in communities, then it might provide federal funds to a particular organization that then uses those funds to carry out that objective, maybe in conjunction with HHS staff, maybe on its own, but it achieves that federal purpose. And these differences ultimately result in two significant changes. The first being the level of government involvement, and the second being the application of which regulatory requirements. So grants are governed by the Federal Acquisition Regulation, and contracts are governed by the Federal Acquisition Regulation, and grants are governed by the Uniform Guidance. So let's start with contracts. Government contracts are governed by the Federal Acquisition Regulation, and we typically refer to these as FAR-based contracts, Federal Acquisition Regulation. So on the screen is an example of what a FAR-based contract might look like. It identifies the procuring agency, it describes the particular services and supplies to be provided, it identifies the quantity of those supplies and services, it includes a schedule, it identifies additional deliverables, and it also has the dreaded FAR provisions. And so why do I say dreaded FAR provisions? Well, FAR provisions are the terms and conditions of the contract and are identified in the FAR itself. So these terms and conditions can either be repeated directly in the contract, or they can be incorporated by reference. So you may have seen a list of FAR provisions that start with 52. So an example would be FAR 52-2714, which discusses rights and data. And then sometimes we'll see contracts with lists of FAR clauses that go on for a page or two. And unfortunately, we've probably memorized most of them. So it's definitely great to have someone who can be in compliance here. But which FAR clauses are incorporated into government contracts depends on the variety of different aspects of the contract. So, what item is the government purchasing, where will performance occur, whether the item is a commercial item, all of this affects which specific FAR clause is included in the contract itself. So to perform government contracts, prime contractors, so the entity that's in contractual privity with the government, will often rely on the use of subcontractors. And as a result, in order to implement its objectives even further, the government will require those FAR clauses to be included or flowed down to subcontractors. And then we should also note that there is a difference between subcontractors and suppliers. So subcontractors generally directly assist the performance of a government contract, while suppliers are generally support the prime contractor in conducting business. And I am going to turn it over to Dave to talk about grants. Oh, Dave, you're on mute. There you go.
Oh, okay. Sorry about that. I just want to say, good afternoon, and once again, thanks for joining us today on this panel. We appreciate your attendance. So I want to talk a bit about grants. So Erica just gave a great summary of some of the challenges and the characteristics of a FAR-based procurement contracts. And from the polling questions, it looks like there's going to be a fair bit of folks in the audience that are going to be more based in the grant world. So with grants, unlike a FAR-based procurement, right? The grant is a different animal. So unlike where in a FAR procurement where the government is buying a good or service and they're going to be your customer, in a grant typically, at least this is how it should work, is that the government is really acting as a partner for you to kind of partner together in order to achieve some kind of objective, for the public good. And so what the government does here is that unlike where it's buying goods and services as a customer, it's going to have typically less involvement. What it's going to do is it's going to make assistance awards, but the actual administration of the award is going to be more heavily placed onto the actual recipient. And so most times what we have and what we see is that we'll have a pass-through entity that will be the recipient, and that entity will then be responsible for selecting subrecipients or other sub-partners to kind of carry out like the overall program objective, as well as making sure that all folks are in compliance. And so the sections that are going to govern grants are going to be found in what we call the OMB uniform guidance, and that's probably very it's going to be found in 2 CFR Part 200 provisions. Next slide, please. And so these are what we call the uniform grant guidance, and as its name indicates, this is guidance. And so these regulations are not self-implementing. It is up to each individual awarding agency to actually adopt parts or all of the uniform guidance that's set forth in 2 CFR Part 200. And for the most part, every awarding agency has pretty much adopted the 2 CFR Part 200 guidance entirely. I will say that there are certain agencies that will also add agency-specific requirements on top of that. So it is important not only to look at the uniform guidance, but also to make sure that that you're cognizant of any kind of special or ad hoc agency guidance on grants as well. One of the very important things, and it's a very factual question, of course, but is as the recipient of the grant, you're going to be the only party that's directly responsible to the awarding agency. So what that means is that it is critical that you make sure that you understand who is going to be a subrecipient and who's going to be a contractor underneath you, because at the end of the day, your subrecipients are not going to be directly liable to the government. So the risk of compliance really, unfortunately, falls upon the shoulders of the recipient. And so one important distinction that we see quite a bit is the distinction between a subrecipient and a contractor. And this is a very important distinction because if you are a subrecipient, you're going to be subject to a lot more compliance requirements. You're going to see like a lot more flow downs. You're going to be subject to audit provisions. You're going to be subject to cost sharing provisions, certain profit restrictions. Whereas if you're a contractor, generally you're going to have far fewer flow down requirements and compliance. And the sort of main kind of division is between, if you're a subrecipient, you're going to really be a partner to the recipient in terms of effectuating the ultimate program, objective, right? You're going to have a role, at the table making decisions. If you're a contractor, what you're really doing is more commercial in nature. So you're going to not be making decisions, but you're going to be providing a service that's going to be more ancillary. And so an example would be of a contractor would be if you have to hire an accounting firm. That is, that's a pretty quintessential example of a contractor in connection, with grants. Next slide. All right, so Section 889, which is a big reason why we're all here today. So next slide, please. So this is something that's been out for, in its first iteration, back in August 13th of 2019. And and it really has multiple parts to it. But let us take a polling question first before we jump right into it. So if you could just take a minute to answer, if you want to kind of gauge the level of knowledge with this section 889. Do you know the implications of section 889? Yes to grants, yes to contracts, yes to grants, yes to both. Have a general idea, or what is it?
All right, Katie, can you let us know the results, please? Oh, I can't see the results. Dave, can you?
I can't see the results. Oh, here we go.
There we go.
Okay, so the results are the one person that said yes to contracts. Nobody answered yes to grants. Okay, it's good to know. Yes to both. We got about 7 responses. We got the most responses in terms of yes, I have a general idea, about 8 people. And then we have about 5 or so in the audience who would like to know more about 889 and what it entails in all its glory. All right, thank you. Next slide, please, Erica. Okay, so the background of Section 889, as I mentioned, this came out as part of the 2019 NDAA. The kind of overarching mandate is that the government is cracking down on certain covered telecommunications equipment and services. So that's a term that that you're going to see over and over again whenever you're dealing with anything Section 889 related. Section 889, in terms of this prescription against covered telecom equipment and services, does apply to both contracts and grants, but in different ways, as we will discuss. Next slide. Okay, so covered telecommunications equipment or service, what is it? Well, it's a very lengthy and it's kind of a run-on definition of the various components to it. But in a nutshell, it covers anything that is telecommunications related in terms of equipment or services that are produced by Huawei Technologies or ZTE or any of their affiliates, and also includes certain other video related equipment produced by other Chinese entities like Aptera, HTZ, and the like. And so that is the sort of general definitional parameters that were given. Now, of course, this also mentions affiliates of these companies, and so that's one area where clients and companies have had to struggle with because unfortunately neither the NDA or the FAR statute or regulations that implement these requirements really come up with any kind of complete list of what all the possible affiliates are, and that can be kind of a moving target. And as you can imagine, it can often be difficult to understand, is company XYZ really an affiliate of one of these, prescribed Chinese entities? Okay, next slide. So applied to contracts. So as applied to contracts, and this is, I think folks are probably going to have a bit more exposure to this, but it has 2 parts. So under the statute in the NDA, there's a Part A and a Part B. Part A is really about, it's a prohibition against selling covered telecom equipment or services to a federal executive agency. Okay, and that became effective on August 13, 2019. So Part A has been with us for some time. So that is geared at not selling such products or services. Part B is a bit newer. So this came out about a year after. It was effective last August 13, 2020. And this one says that if you're going to be a federal contractor with any agency, you are not to use any covered telecom equipment or services. Next slide, please. Okay, so I mentioned that the 889 is really a product of this, the 2019 NDAA, and so it is implemented through principally three regulations in the Federal Acquisition Regulation. We have 204-24, we have 204-25, and we have 204-26. In a nutshell, in terms of your representation as to whether you as a contractor will or will not sell or use covered telecom equipment or services, those representations and any kind of extenuating circumstances are going to be captured within 24 and 26. Dash 25 is really the sort of heart of the substance in terms of the actual prohibition, and it also does have certain exemptions, if you will, which we can discuss later. Next slide. Okay, compliance. At a high level, very broad compliance. Okay, so this is going to apply to all federal prime contracts, regardless of size. And this is going to include contracts that are below the SAT, which stands for the Simplified Acquisition Threshold, which is now about $250,000. It's been recently raised. And it also applies to cost items. And so it's very expansive. Now, for Part B, which is the prohibition against internal use, it's not limited to contractors who sell telecom equipment. These provisions are also not limited to U.S. companies, so it can apply abroad. It's also not limited to performance on federal contracts, and I'll discuss that a bit more in just a second. But it is going to be limited to the specific entity that is contracting with the government. So we're not including affiliates. Okay, so one sort of hot issue in the world of Section 889 is requirements for subcontractors and suppliers. So Part A is supposed to be a mandatory flow down to subcontracts. And obviously, this is to ensure that the prime contractor has a sufficient basis not to actually sell covered equipment and services to the government. Part B is the prohibition against a contractor's own use of said products and services, right? And that does not require to be flowed down. But as a practical matter, in order for any organization to have a reasonable basis to be comfortable that it is not using said product or services, we find that many entities do flow that down, even though arguably it is more voluntary. Next slide. Okay, so Part A, in my mind, is a bit easier because we're talking about sales, right? And so not this, and I'm not trying to minimize it because, there are some fairly significant compliance issues and sort of supply chain management issues and making sure that covered product do not enter, like your supply chain. But Part B is a bit more nebulous. So this is, as I mentioned, this requires a contractor to make a representation that it does not use covered telecom equipment or services, right? Or any equipment or service that in turn uses, covered telecom equipment or services. And so one important kind of point is that the Part B prohibition does not mean that it goes beyond just whether or not you're going to be using this equipment or services in connection with performing a contract. You can actually just use that internally as part of your infrastructure, not directly in support of a federal contract, and potentially still trip up with Part B. So that's the kind of very expansive mandate that a lot of clients seem to be wrestling with, and rightfully so. So now, recognizing like the breadth of the Part B prohibition and the burden on industry, in the FAR clause, which is the 52-204-25 that I mentioned a few slides ago, there is a sort of standard. Okay, so it's not a strict liability because people understand that you can't 100% bet. But what you're supposed to do under Part B to make sure that you're not using prescribed telecom equipment or services is to conduct a reasonable inquiry. Unfortunately, beyond the words reasonable inquiry, there is not much more detail as to what that means. So, except to say that you don't have to do a full-blown audit. That's helpful. So at least we know that you don't have to hire, a consultant or auditing firm or do a comprehensive internal audit. You have to have some kind of system, however, that is going to be reasonably designed to uncover information in your possession, custody, or control about the identity of the producer or provider of the products that your organization is using, so that you can then make an informed judgment as to whether or not you think you may be at risk of using covered telecom equipment or services as part of your own operations. Next slide. So what are the open issues and compliance pitfalls? Well, it's probably would be easier to have this the other way and say what isn't open, but here are some of the open issues and compliance pitfalls. So what is use, right? Classic example would be, for example, your entity contracts with FedEx, right? And you don't know what kind of systems or equipment FedEx uses. Do they use covered telecom equipment and services as part of their operations? And if so, does that somehow mean that you can't deal with FedEx even though all they're doing is helping you ship boxes? Open question. Again, also it's not limited, to use on a federal contract. We get a fair number of questions about, well, why do I have to comply with this? I mean, this is just for my own private use, right? As part of my organization. We're not using any of these product or services in support of carrying out any kind of federal contract or any kind of grant objective. Unfortunately, the regulation is broader than that. Another one is, what is this, right? Those definitions, that we looked at a few slides ago are incredibly dense, and they're written in a very, it's accurate, but it's sort of hard to piece together, right? And so understanding, well, what is telecom, equipment or services? Is it A, covered? And B, if it is covered, is it still somehow permissible? Because there are some arguable, exceptions to that, right? Which we can talk about a bit later. C, we talked about it just, in the last slide. What's the reasonable inquiry? Okay, so you're telling me I don't have to go and retain, Price Waterhouse or KPMG or any accounting firm of your choice to kind of do a full-blown thing. But what is enough, right? And then the last one is, okay, so how do I protect myself? As part of this, reasonable inquiry process, when do I and how do I flow down these requirements, whether it's a direct requirement as part of a contract or it's a rep and cert. So these are some of the open questions. Next slide. Okay, as applied to grants. Next slide. So we just spent a lot of time talking about contracts and how it is just a lot of open issues and questions. I will say that at first glance, you might think that as applied to grants, it's a bit easier because there is a different prohibition. So basically, under Part B1 of the statute, all right, and this has now been subsequently integrated into the uniform guidance, but it says that if you're a grantee, you cannot use federal funding, right, to buy or obtain or to basically have a contract, right, that is going to buy or obtain or use covered telecom equipment and services. So the critical difference between a FAR-based contract and a grant contest for purposes of Section 889 is that under the FAR, you can't do it. Under grants, you can do it, but you got to be careful, because you can't use federal money to do it. Next slide. So the Section 889 Part B1, right, which is about the grants, has been implemented into the grant world through two additions to the uniform guidance. So the first one is 2 CFR 200.216. So that is the actual guidance provision that states the prohibition. That's the one that says you can't expend federal money, obligate or expend federal money in connection with procuring any kind of covered telecom equipment. The other one that's sort of a companion piece to this is 2 CFR 200.471. Now, this is the one, for those that in the audience who deal on the cost side, this is one of the new cost principles, right? So this was effective last November of 2020, but now it actually makes it, unallowable any cost that that was used to procure or obtain covered telecom equipment or services. Okay, so again, both these clauses are tied to funding, right? You can use covered telecom, you just cannot use federal money to do it. The other important thing I want to quickly make sure is that these provisions apply not only to the initial recipient, but it does apply to all your subrecipients. Next slide. Okay, so who must comply? So I won't repeat myself. It applies both to recipients and subrecipients. Okay, and like the FAR rule, it's not geographically or domestically limited, right? So it applies abroad. And one interesting thing that some of the audience may have experienced is, okay, I have a subrecipient in certain parts of the world where Huawei is the predominant product. What do I do, right? Another question. It's a great question. It's something that a lot of people are struggling with. Under the uniform guidance provisions, it's supposed to apply to new awards or renewals or extensions of existing awards. And there's also sort of a very interesting kind of division depending on which agency is your awarding agency. Unlike the FAR provision, I'll make this quick because we want to get on this to some other things, but it is not entirely clear whether the new uniform guidance provision, that 216 and the 471, apply to grants that were in effect as of the effective dates of those provisions, right? Or they only apply to new grants, new awards after that date. And depending on which agency is your awarding agency, that could be a different answer. Next slide. So what are the issues? Well, it's a lot of the same issues, right, as the ones that we're talking about with the FAR, right? We're talking about, you can't, in this case, you're not really going to be selling, as a grantee or as a subrecipient, you're not going to be selling product to government. But so this is really, it's really going to be focused on the use of covered telecom equipment and services. But in terms of that, there's going to be a lot of parallels and overlap in terms of the same sort of compliance issues and pitfalls and just sort of open questions that everyone's dealing with. Now, unfortunately, even though you might think, okay, well, I can use, covered telecom, I just can't, use federal funding. Unfortunately, from what we've seen, that can be kind of a difficult endeavor, right? Because now we're sort of getting into, cost accounting issues, right? So, we're talking about, part 400 we're subpart 400, and we're talking about allowability costs, and now we're starting to kind of talk about how do we document and make sure that we have adequate documentation that's contemporaneous, that's going to be able to show that all our purchases under the contract for our award are not for purposes of acquiring covered equipment or services. So that's a challenge there. And because the problem is, if we don't have the adequate kind of records management approach, or if we have contracts that are dealing with what we call unbranded products, right? So the phone doesn't say that it's from Huawei, right? But maybe it contains Huawei components in it. So that is sort of the compliance part. And I think that what we've seen is there's a growing emphasis and questions surrounding how do I make sure that my audit plan and that my record systems and my purchasing systems, my internal controls and my accounting systems are going to pass muster, because when I go through a single audit, I don't want to have these costs disallowed, right? I don't want to have to undo it and be on the defensive. So just to recap, audit, it seems to be a very important area that if your organization is going to decide to make the decision to use covered telecom, really got to have a plan kind of already in place, right? To make sure that we're properly tracking costs and segregating costs to make sure that we have a defensible audit position. Next slide.
Hey, Dave, before we move on, I wanted to talk a little bit too, just going back to compliance for Part B for contracts. Part of the covered telecommunications equipment or services definition, limits it to substantial or essential component or of any system or as critical technologies of any system. So, I've had clients come and say, hey, listen, I've done the reasonable inquiry. I've identified that I have Hikvision cameras in my facility that monitor temperatures for COVID-19 reasons. And Erica, it doesn't seem like, they're substantial. They're not involved in anything. We've got, 2 cameras in a whole facility, and the rest, 98 of them are, not Hikvision or any other sort of any of the other Chinese companies. What do? Do we need to get rid of them? Can we still make the representation to the government that we don't have any covered telecommunications equipment or services? And the answer is no, you can't make that representation. So you actually have to mark no, because you know that you do have covered that qualifier of substantial or essential component of any system or as covered technology of any system. That qualifier is for the agency to determine. So you have to identify literally any use, your one Hikvision camera in your entire facility, and then ask the agency essentially, or explain to the agency why it shouldn't be considered a substantial or essential component of any system or as critical technology. And so a lot of contractors miss that quick little qualifier, really, because it's not up to them to determine what that is. It really is up to the agencies, and frankly, the agencies don't have much more guidance than we do, but it is ultimately their decision. So that's one quick thing I wanted to flag on that certification. It can be a little tough. And then I think the follow-up question to that is, okay, Erica, we found, okay, this Hikvision camera. What do we do now? Do we get rid of it? Like, do we have to? And I think depends, obviously, because that's a lawyer's favorite answer. But I think if you have kind of, enough that you're going to be disclosing this on every single contract, it is kind of easier if you can represent that you have nothing and that you're just going to move forward with performance. And this is something that you don't have to deal with. So, or you don't have to allow the contracting officer to have any discretion about. So I'm going to move on to the next question, which I believe is for Sarah.
Yep, thanks, Erica. So now that we have covered the supply chain security issue with Section 889, we're going to transition to a related but slightly more specific issue of cybersecurity. So we're going to start out with another polling question on here. And that question is, do you have any U.S. Department of Defense contracts or subcontracts? Yes, no, or unsure. So as we'll get to here, there are a few different regimes here that we have in cybersecurity based on different agencies, and then as Erica will get into later, based on grants. So we just kind of want to see what you all have out there right now. All right, and if we've got a critical mass here, Katie, could we get the results? Okay, so it looks like we've got a good number of you out there with DoD contracts. So we've got a great thing coming up. You probably know CMMC on that. And then a few of you who don't, and a few of you who are unsure. So I'm going to first kick it back to Erica to talk about cybersecurity generally across all contracts.
Thanks, Sarah. So there are some cybersecurity requirements that relate to, that are included in FAR-based contracts that apply to civilian agencies in addition to the Department of Defense. So the first one we want to flag for you is FAR 5220421, which is entitled Basic Safeguarding of Covered Contractor Information Systems. And this requires certain controls that are must be implemented if a company stores, transmits, or processes federal information. It applies to all contractors and subcontractors at any tier. So you could be the 5th subcontractor down, and you are still going to see this in your contract if you're above tier. Subcontractors are doing their job correctly and limiting their risk. So what are these 15 controls? They're pretty much things you probably already have in place. So they include authenticating identities of persons accessing the information systems, limiting physical access to these information systems and other equipment, as well as the operating environment. It requires escorting visitors or maintaining and monitoring visitor logs. So things that you pretty much have seen in typical access control environments that, for example, if you have export controls, you probably are implementing, similar restrictions. So the second FAR clause we want to flag for you is 5220423. And this is the prohibition on contracting for hardware, software, and services developed or provided by Kaspersky Lab and other covered entities. So Kaspersky Lab, for those who don't know, is a Russian entity that is been deemed by the U.S. government as a national security concern. Accordingly, contractors or agencies, cannot procure Kaspersky Lab products, and you can't also use them. Contractors can't use them in performance of government contracts, and that those are kind of cybersecurity items that they have, and just cyber defense services that they provide. And then the last one is FAR 52224.3, which is privacy training. So privacy training might be a little bit more applicable to academic medical centers and research universities because it also applies to the handling of personal identifier information. So if you as a federal government contractor are handling personal identifier information, which usually is contained if the agency is in an actual possession and you are using it in performance of your government contract, or you are collecting it on behalf of the government, it's usually contained in what's called a system of record. And system of records must be actually published in the Federal Register. The agency has to identify that it has a system of record and frankly justify why it needs to collect this personal identifier information, either about government employees, about veterans, about patients, about whomever. So when a contractor is working with the agency and has access to a system of records or is maintaining one on behalf of an agency, they're required to implement various trainings and implement various procedures to ensure that the information is protected. And so that's an annual requirement. So then I'm going to flip it over to Sarah to talk about CMMC.
Yeah, so moving to specifically the defense agency side of contracting, those of you who have defense contracts, as you indicated, may have been following over the past couple of years the development of a new cybersecurity framework for the defense industrial base specifically. So that framework is called Cybersecurity Maturity Model Certification, or CMMC. And it was developed by DoD and is meant to assess contractors' ability to safeguard federal contract information and controlled unclassified information. So this model does not cover classified information, but is about protecting pretty much every other type of information associated with a defense contract. And the goal of this framework is similar to the FAR clause that Erica was talking about on the last slide, the 204-21, but it's just a much more detailed model and framework associated with those same goals. So what does the model look like? CMMC is organized into 5 different levels of certification that contractors can achieve, starting with basic cyber hygiene at level 1 and ranging up to proactive and advanced cyber practices at level 5. So in total, the model consists of 171 different practices across these 5 levels that themselves are organized into 43 capability groups and 17 domains. So the domains are areas like access control, incident response, physical protection of facilities, just different types of compliance areas that you would worry about, cybersecurity. And the practices are more specific activities within those areas, like Erica was talking about on the last slide, like limiting access to certain users in your system, or literally having a security guard in front of sensitive facilities. So things like that. And it's important to remember that the framework is cumulative. So at level 3, you have all of the practices that are associated with level 3, but also you must be complying with level 1 and level 2 at that point. So then all the way up at level 5, you're complying with all 171 practices within the model. So the domains, capabilities, and practices were built from first those 15 controls that Erica was talking about on the last slide, as well as cybersecurity controls and standards from NIST, from other U.S. cybersecurity frameworks, and even international cybersecurity standards from the UK and from Australia. And in addition to these practices, the last piece of the model are the 5 maturity processes, which are not the activities that you must actually do, but the level of implementation and integration that you've worked those activities into your company. So for example, at level 1, the required process is simply to perform an activity, while at level 2, you would be required to not only perform it, but also have documentation about that activity. So a policy that relates to how you limit information. And then up and up into level 5, where you have a completely integrated system within your company. So next slide, please, Erica. And so utilizing this model, defense contractors need to figure out which level of certification they want to achieve and then actually get that certification by doing an assessment. So within CMMC, there is no more self-certification, and certifications can only be completed through third-party assessments. So these are independent assessors that are certified through an entity called the CMMC accreditation body, the CMMC AB, and we have a lot of acronyms here. But that is an entity, it's a nonprofit entity that DoD has a memorandum of understanding with that they've agreed to kind of just run the logistics of this entire certification process. So they are going to have or are setting up what's called a marketplace, where they can list the assessors that are out there that they've provided training for and that they've certified, and that contractors can then go in and match up with an assessor, can hire them to complete your assessment. And within that marketplace, the CMMC AB is doing a lot of other certifications and trainings with different types of organizations, for example, consultants that could help you prepare before you're actually completing an assessment. So there are going to be a lot of resources, through that, and to actually be able to match up with an assessor and get a certification. So moving on to the actual scope of this, who really needs to deal with CMMC? So the answer to that is, again, very broad. That would be all contractors doing business with defense agencies. So that includes not only the primes that are signing the contracts in privity of contract with the government, but also subcontractors all the way down the supply chain within those primes. And the only contracts that don't require or that will not require CMMC are those for COTS items or contracts under the micro purchase threshold. So there are a few carve-outs that are different from the Section 889 that Dave talked about, but still very broad, all prime and subcontractors apart from those two. And so to know what CMMC level you actually are going to be required to have, you're going to be looking at the solicitation itself. So once CMMC requirements are being put into these DoD contracts, you will see that in the actual solicitation, and that is a level that you will have to achieve by the time of award of a contract. So it's not at the time of proposal, but it's also not at the time of performance. To actually get the award, you have to be meeting that CMMC level that is in the contract. For subcontractors, it's a little bit different. It actually depends on the type of information that you're going to be handling. So we all know that a prime contractor, is going to be having a lot more information and passing information with the government that perhaps a subcontractor who's not working with sensitive supplies would be handling. So for a subcontractor, it really just depends on what the prime is passing down to you with regard to how sensitive that information is to know whether, you need to have a level 1 certification or a level 3. So that will be communicated based on the actual flow of information. Next slide, please. So this all sounds rather intimidating, I think, but the requirements that I've just gone through are going to be implemented gradually over the next 5 or so years. So an interim rule that does allow DoD to put CMMC requirements in contracts was effective November 30th, 2020, but DoD has been clear that it's planning to roll out full CMMC requirements over the next 5 years. So within the next year or so, DoD has said that it's going to have 15 contracts with CMMC in fiscal year 2021, and so that doesn't just mean that 15 contractors, though, would need to have this certification level because you have all those subcontractors underneath. So DoD has already announced some of the contracts that it plans to have these CMMC requirements in FY21, and they're large procurements that are going to have a number of subcontractors and are going to have a number of entities that are requiring a CMMC certification within fiscal year 21. And then looking 5 years out, the full implementation of CMMC will be by October 1st, 2025. So starting on that date, all new DoD solicitations and contracts will have CMMC requirements. And then the last bit that I will leave you with for those couple people who maybe don't even have DoD contracts is that DoD has mentioned it does expect civilian agencies to pick up on this framework and implement something similar within, the next several years. So we've heard there may be more information coming out about this later this year. So we will stay tuned for that.
Thanks, Sarah. I'm going to talk about cybersecurity requirements for grant recipients just briefly, because we do already have some questions in the chat we hope to get to. So there aren't a ton of specific requirements for cybersecurity compliance for grant recipients. The biggest is in the internal controls provision of the OMB uniform guidance at 2 CFR 200-303. It requires effective internal control over the federal award and then reasonable assurance that the federal award is being essentially properly managed. And this specifically includes implementing reasonable measures to safeguard protected personally identifiable information and other sensitive information that a recipient or subrecipient may have in connection with the grant. And again, you can probably imagine that a lot of those are going to be similar to the cybersecurity requirements for civilian agencies and that we previously talked about. So what specifically we're talking about are one of two standards, either the Comptroller General's Standards for Internal Control in the Federal Government, which is called the Green Book, or the Committee of Sponsoring Organizations of the Treadway Commission's Internal Control Integrated Framework. So these two standards have the same 5 components. You need to have a control environment, you need to conduct a risk assessment, you need to control activities related to the sensitive information, you need to provide information and maintain communication, and you need to monitor your compliance. So not a huge lift on the grant side for cybersecurity compliance. If you're meeting the obligations on the FAR contract side, you're likely also meeting these requirements. it's always good just to double check and review with your cybersecurity folks to make sure that these standards indeed are met. So with that, I will flip it to Sarah, who is going to administer our Q&A.
Great. So I will switch into a moderator role here. We've had some great questions coming in. I will just start with this one. Dave, you had mentioned some exceptions and waivers earlier when you were talking about Section 889. Could you elaborate on what those exceptions and waivers are for both grants and contracts?
It's actually going to be pretty much the same. You want to call it exceptions or waivers, right? So they all kind of pull from the Section 889 statute, but the two principal I guess kind of buckets are going to be where you have covered equipment or services that are not a substantial or essential part or represent some kind of critical technology aspect of a system, right? So that's a sort of, not really, it's more definitional, but I kind of view that as an exception. So that's one bucket. In the FAR, as well as in the statute under the 2019 NDAA, there is also what is more of a true exception. So those two, I'm just paraphrasing, are going to be, products or services that are really intended for kind of backhaul services. That's one. And then two is where the components for the equipment or services do not have any kind of technical capability to route or reroute data, right? And so when you look at 889, it's really kind of a two-stepper in terms of analysis. The first step is this even covered telecom equipment or services? That's definitional. Then B is like, okay, if it is, can I still use it, right? Because it's not, because we want to make this clear, it's not that just because it's covered means that you can't use it. You can. Now, there's some other business issues that whether you want to do that, which is kind of probably going to be beyond the scope of this, but yes, those are the sort of general, carve-outs, if you will. Sarah.
Great, thanks. And that actually kind of leads into the next question. What are the consequences of non-compliance? So you had mentioned just now, that you can still use it, but what happens? And what happens, if you make your representation incorrectly?
Sure. So, I'll just kind of quickly kick it off on the grant side. So I mentioned that there's 2 CFR 200.471, which is a relatively new sort of cost principle on allowability, right? So commensurate with that, as folks in the audience know, whenever you submit a sort of cost report or submission, you're technically supposed to provide a certification. You're supposed to certify that the contents of your submission are true, complete, and accurate, that they're consistent with the terms and conditions of your award, right? Which would probably include this provision under point 216, right? And the standard is, and that you're certifying that this is to the best of your knowledge, right? And so, that's the sort of representation that you're making. Now, if it turns out to be wrong, there's several ways it can go. On a programmatic side, if you can't defend your costs, right, during the audit, then you could get a disallowance of costs. The government agency could decide to withhold payments. There could be more serious sort of administrative issues in terms of worst case potential sanctions in terms of suspension of the department. Suspension from being eligible to continue performing work. And because of that certification language, there is a potential, I'm not saying, can't in terms of like how likely it is, but anytime, you make a certification with that kind of language, you could possibly have some exposure under Civil False Claims Act. But the primary impact is going to be how do you unpack the costs, right? And the costs in terms of the impermissible covered telecom equipment services is going to impact both your direct as well as indirect. So, in an indirect, you're going to have to figure out a way to pull that out, which could be very, very difficult, time consuming.
Great. So I think we have time for maybe just one last one. I had mentioned in the CMMC piece 2 different types of information you might be handling with contracts, FCI and CUI. So we just had a question about what the difference between that is and how you know if you're handling one or the other. So I'm going to kick that one to Erica.
Thanks, Sarah. And just so you know, if you asked us a question, we will follow up with you after if we didn't get to it. But FCI is federal contract information, and CUI is controlled unclassified information. And FCI is generally information that the government is providing to you as a contractor in order to perform a contract. And controlled unclassified information takes a variety of forms, but it could be generated for the government or be provided to you by the government. Most people know commonly that export controlled information is CUI, personally identifiable information is CUI, personal health information is PHI is also CUI. So the government will mark what it's providing to you, whether it's from a third party, whether it was generated by the government internally. The government will mark FCI as well as CUI and explain exactly what it is that the restriction is on there. So if you are seeing on any documents you're receiving from the government, those markings, you know you have CUI or FCI that you need to properly protect. And, you know, a good rule of thumb is, you know, non-public information that the government is providing you. So it's not necessarily your contract itself, which is FOIA-able. It might be a third party's, you know, proprietary information that you're using to perform a contract. It might be, you know, internal sensitive information that the government has about strategic buying choices, or perhaps, again, PII that it wants to use to further research something. So there are a lot of different buckets in which CUI and FCI have their toes, but usually all is marked, and you have an understanding of whether you're going to receive that in performance of a contract. So I just wanted to say, you know, with that, I just wanted to say thank you so much for joining us here today. We greatly appreciate your time. We will follow up with everyone who asked questions that we didn't get to, and we hope you have a great rest of your day.